one to whom we can look to tonight, we come and we humbly bow ourselves in your presence, acknowledging that you alone are perfect in wisdom, limitless in knowledge, and unfailing in justice. We stand in a world, Lord, that we depend on human judgment, but we know how frail that can be, as we depend on facts sometimes that are not facts. But you, the ultimate judge, you know it all things, because all things lie bare before you. It is for that reason why we come to you tonight and we appeal to you to come to where we are, because we need you. We need you to direct us. We need you, Lord, to guide us. We need your strength and we need your wisdom. We ask that, God, you will truly be at the center of what we're about to do. We invite you to be more than just an emergency exit for the time of trouble. We need you to become our main entrance. Because we need you not just tonight. We're going to need you tomorrow. We ask you, Lord, to be in our midst tonight, that you'll cause your face to shine upon us. Allow heaven's blessings to be ours. We ask that you'll intermingle with us, guide our thoughts, and the information that we're about to glean, give us the ability to dissect and to understand. We ask that now, God, you'll rest your grace upon us, and we lean upon you and rest in you, and we thank you for heaven's choice blessings. Amen.
Please be seated. His Lordship, the Honourable Mr. Mario Michel, Acting Chief Justice of the Eastern Caribbean Supreme Court, Premier of the Virgin Islands and Minister of Finance, Dr. the Honourable Natalia Wheatley, Honourable Judges of the Court of Appeal and the High Court of the Eastern Caribbean Supreme Court, Honourable Ministers of Government of the Virgin Islands, Director of Public Prosecutions of the Virgin Islands, Mrs. Tiffany Scatliff, other members of the House of Assembly, the chairpersons and members of the Service Commissions of the Virgin Islands, the Financial Secretary, Cabinet Secretary, and Permanent Secretaries of the Government of the Virgin Islands, Registrar, Ms. Vereen Vanterpool-Nibs, and Deputy Registrar of the Supreme Court of the Virgin Islands, President of the OECS Bar Association, Ms. Jean Dyer, who's online, President of the BVI Bar Association, Mr. Scott Tollis, and other presidents of the constituent bar associations of each of the OECS member states and territories, learned members of the Inner Bar and Outer Bar of the Virgin Islands and each of the OECS member states and territories, members of the clergy, staff of the court's headquarters and court offices in each of the OECS member states and territories, distinguished guests, citizens, residents of the Eastern Caribbean. Good evening. I know sometimes we're always happy when that protocol list is over. So, good evening. My name is Michelle John Thibbles. I am the Chief Registrar, and the pleasure has been given to me to be the moderator for this evening's lecture. I'm delighted to see so many of you here today. It's also very heartwarming to see how many persons from across the region have tuned in online to be a part of yet another milestone event of the Eastern Caribbean Supreme Court. To those of you viewing online, today's lecture is being broadcast live from the conference room at Maria's by the Sea in Roadtown, Tortola, via the court's website, the GIS in Tortola, and UWI TV. Almost a year ago, when our current acting Chief Justice was placed at the helm, he outlined to us what his vision was for his tenure at the court. While we at the court had made many strides in technology and our procedural rules, His Lordship thought that there was more that we could do in relation to our image to the public. You see, although the public knew of the existence of the court, it was very apparent from the corridor conversations or even street conversations with citizens that their knowledge of the role, purpose, and workings of the court system left much to be desired. His Lordship was determined to remedy this from within. It is through this desire that the ECSC's public education campaign was born. Over the past year, the court has embarked on a number of components of this campaign, one of which is the public lecture series. The first electrifying, and dare I say, technologically provoking lecture was delivered by the exuberant Attorney General of St. Kitts and Nevis, the Honourable Garth Wilkin. Today, we are excited to present the second part of the series on the topic, The Court, ADR and You, brought to you by an equally dynamic presenter who you will hear more about in a few moments, His Lordship, the Honourable Vasheist Kokaram, Justice of Appeal of the Trinidad and Tobago Judiciary. As we commence our proceedings, we are delighted to have with us the person charged with the responsibility of giving the official welcome. I am told that he is a proud Virgin Islander with ancestral roots going back to the period of slavery. He has taught at various levels in educational institutions in the Virgin Islands, and he has a strong record of community involvement, of which he is proud. He is also very well learned and degreed up with a Bachelor of Arts in English, a Master's of Arts in Literary Studies, and a Doctor of Philosophy. Distinguished guests, I can think of no better person to bring us the official welcome other than Dr. the Honourable Natalia Wheatley, Premier of the Territory of the Virgin Islands. Please make him welcome.
Thank you so much. Good evening, everyone. I recognize the protocol which has ably been established, and I particularly wish to welcome to the Virgin Islands the Acting Chief Justice of the Eastern Caribbean Supreme Court, His Lordship, the Honourable Mario Michel, and the 10 other esteemed Justices of Appeal who are visiting with us for this week's sitting of the Court of Appeal in the Territory of the Virgin Islands. These are in addition to the 5 High Court judges presently serving in the Territory, and I certainly acknowledge all other distinguished guests here today. My love and appreciation for having you here has no bounds. May I also extend a special welcome to Justice Vasheist Kokaram, who is the guest speaker for this evening and who is a prolific jurist and an expert on the court and alternative dispute resolution measures. The people of the Virgin Islands are very happy to have you with us. For those of you who may not be familiar with the Virgin Islands, we are one of the region's wonderful tourist destinations with pristine white sand beaches, calm and friendly sailing waters, picturesque views, an archipelago of barely touched islands and keys, colorful reefs and dive sites teeming with marine life, and excellent restaurants and bars, both on and off the main islands. I hope your schedules allow you the opportunity to experience at least a taste of what the BVI has to offer, and that you are encouraged to return with your families for a relaxing vacation at one of our world-class properties or for a sailing charter. The Virgin Islands has had a long and close relationship with the Eastern Caribbean Supreme Court. not only because of the fact that the immediate past Chief Justice, Dame the Honourable Janice M. Pereira, DBE, PC, hails from Virgin Gorda, one of our main islands, something of which we're extremely proud. While there are general standards and understandings of right and wrong, and what is just and unjust, there's a belief that in judging the conduct of persons, it is important to give consideration to the construct, culture, and conditions of the society, which varies from country to country, jurisdiction to jurisdiction. Law and its administration is not a cookie-cutter process. The Eastern Caribbean Supreme Court, with its diverse composition of eminent jurists who have lived and practiced throughout the Caribbean, undoubtedly has an upper hand on other judicial bodies when it comes to being able to understand the collective and individual characteristics of the states and territories in this part of the world. And with this in mind, it is possible for litigants to walk away feeling that their issues have been fairly adjudicated because of the arbiters were knowledgeable of and sensitive to the social contexts and factors that may have been involved in the matter. The large number of matters that are litigated through the Eastern Caribbean Supreme Court speaks volumes of the confidence that the public has in the court. And this is not just among Virgin Islanders. The Virgin Islands is an international finance center, which means that there are individuals and corporations from almost every jurisdiction on earth engaged in contracts, transactions, and business in the Virgin Islands, often involving very large monetary amounts. One of the most critical factors in being able to draw and maintain this kind of business is confidence in the courts to deliver justice when called upon to resolve a dispute. Countries like the Virgin Islands do owe a lot to the Eastern Caribbean Supreme Court, and for this we say thank you. While on one hand, the courts enjoy a high level of confidence, there has been a growing tendency for persons to seek relief and resolution to disputes through alternate dispute resolution, or ADR. The main reasons for this are well known. ADR is generally more cost-effective than traditional court processes. By choosing mediation or one of the other ADR measures, parties can avoid costly and time-consuming trials and save time and money. ADR offers a more informal and flexible approach to dispute resolution, whereas court processes can be more rigid, require certain formalities, and can be adversarial. In ADR, parties can tailor the mediation process to meet their specific needs and interests, fostering a more collaborative and client-centric approach that can yield a settlement that is more likely to be accepted by both parties. ADR also promotes early resolution, which can save parties the stress and aggravation that can develop from the conflict being protracted. Finally, ADR can reduce the workload on courts, especially with cases that are easier to resolve, allowing judges to focus on more complex legal issues that will help with the evolution of the jurisprudence. As most should be aware, the Virgin Islands is home to the BVI International Arbitration Center. The BVI Arbitration Center offers a number of conveniences, from large state-of-the-art meeting room facilities to a roster of over 200 ADR practitioners who can conduct arbitrations in a number of languages, including English, Spanish, Portuguese, Russian, Chinese, French, German, and Italian. These services are well subscribed, attesting to the increasing popularity of ADR. Having said this, I think the initiative by His Lordship, Acting Chief Justice Michel, to conduct this public education lecture series is very timely. I thank you for your vision. It is very important for persons to be aware of the options available to them to attain relief and justice whenever they believe they have been wronged. Knowing this, they are better equipped to seek out justice. The declaration of justice can bring closure to worried minds. When wounds are not closed, when they remain open, they can fester and cause problems to escalate down the road. But when a matter is resolved, there's the chance of it being put to bed and persons can move on with their lives. For persons who do not have the means to hire lawyers or the patience to endure lengthy court processes, ADR is an opportunity for them to access justice and closure as well, instead of having it forfeited from them for lack of means or information. There are many persons who could benefit from ADR, but they are unaware that this is an option available to them. So again, I commend the choice of topic for this evening's public education lecture, The Court, ADR and You. I hope the deliberations and messages from this evening's lecture are carried far and wide to the populations of the various countries that are subscribed to the ECSC and beyond. I hope that your message reaches those who need to hear it the most, that for certain problems and disputes that are affecting them, they may be able to obtain relief through the courts or through ADR. Once again, I welcome all our guests to the beautiful Virgin Islands, and I wish you a pleasant and memorable stay with us. I thank you.
Thank you, Premier. Earlier, I shared with you a glimpse of how the ECSC's public education campaign was conceptualized and the distinguished person responsible for it. His Lordship, who is a graduate of the Faculty of Law of the University of the West Indies and the U. Wooding Law School, entered into practice of law in 1984. During his career, His Lordship was very active in civil society, becoming the founding president of the St. Lucia National Youth Council in 1985, president of the St. Lucia Guild of Graduates in 1991, and president of the St. Lucia Bar Association in 1996. Between 1997 and 2000, His Lordship diverted his attention to the political sphere, but he would inevitably return to his true passion, the law. In 2009, His Lordship was appointed as a High Court judge and was elevated to the Court of Appeal in September 2012. On the 5th of May 2024, His Lordship was appointed as Acting Chief Justice of the Eastern Caribbean Supreme Court. Ladies and gentlemen, distinguished guests, it is my pleasure to invite to the podium to give brief remarks His Lordship, the Honourable Mr. Mario Michel, Chief Justice. Please make him welcome.
Thank you, Madam Chair. I have noted the list of persons whom the Chair has called out in her opening remarks, and I will adopt the list as mine so as not to have to repeat the names and offices of the several dignitaries in attendance at the lecture this evening, whether virtually or in person. I can't help but note that when the Chief Registrar was delivering her opening remarks, or had delivered them, I wondered whether I still need to speak. But when the Premier delivered his welcome remarks, I thought our guest speaker yes, I did think that you're in danger of being repetitive. But that was a brilliant introduction to the subject matter, Premier. I commend you. But permit me, Madam Chair, to commence my brief remarks by expressing my appreciation and that of the Eastern Caribbean Supreme Court as a whole for the presence this evening in person of the distinguished Premier of the Virgin Islands, other ministers of government, members of the House of Assembly, principal officers of the government of the Virgin Islands. Permit me also to thank the Premier for not just his words of welcome and his very scholarly discourse on ADR, but to also thank him for the expression of support to and for the Eastern Caribbean Supreme Court. The very strong signal that these manifestations of support give and send enable us to better undertake the public education campaign on which we have embarked. Because without the support of the executive and legislative branches of the governments of the countries which we serve, the Eastern Caribbean Supreme Court, which is the third branch of the governments, will not have the bandwidth to reach the publics whose interests and attention we are endeavoring to obtain and maintain. Madam Chair, the raison d'etre for the public education campaign, which we began in September last year, is to communicate with the people of the states and territories served by the Eastern Caribbean Supreme Court, and to educate them about the court as an institution and about the court system as a whole in the states and territories. You may be alarmed to hear some of the utterances of people at all levels in our countries speaking, whether from the street corners or the parliament chambers, about our court and the court system in our islands, in terms of the lack of awareness, to put it generously, that these utterances may betray. To correct this lack of awareness, we have embarked on a public education campaign comprising several components. The first component of the public education campaign, which is the conversations, as I prefer to call them, with the students at the major national tertiary level institutions in the member states and territories of the Eastern Caribbean Supreme Court, was commenced last year, September. I have since then addressed students at the community colleges in Dominica, Antigua and Barbuda, Anguilla, St. Lucia, Montserrat, Grenada, St. Vincent and the Grenadines, St. Kitts and Nevis, and yesterday I did so at the H. Laverty Stout Community College in the territory of the Virgin Islands. This visit yesterday completes this component of the public education campaign, dialoguing face-to-face with the students whom we expect in due course will be the leaders in the economic, social, and political spheres in our countries. The conversations with the students have been very fruitful and have revealed both the need for and the thirst for such activities. Another major component of the public education campaign, which we've started, is one which has been called Conversation with the Chief Justice, which has thus far taken the form of an extensive interview with a media professional in St. Lucia, which was disseminated and broadcasted by media houses and social media platforms in the member states and territories during the months of February and March, and which I believe can still be viewed and listened to on the website of the Eastern Caribbean Supreme Court. There are other conversations with the Chief Justice which should take place in the course of the next few months. The third component of the public education program, which has started and is ongoing, is the public lecture series, which aims to target leaders in government and civil society and members of the public with a view to broadening and deepening understanding of law and legal systems in contemporary society. The first of the lectures was delivered in St. Kitts in October last year by the Attorney General of St. Kitts Nevis, Senator the Honourable Garth Wilkin, on the topic, and I quote, "Justice Without Borders, the Legal Practitioner's Perspective and the ECSC Reality," end of quote. Senator Wilkins' lecture was very well delivered and very well received, both by those who attended in person and those who were in attendance virtually. This evening, we are presenting the second lecture in our public lecture series on the topic, The Court, ADR and You. This topic was selected because of the importance of alternative dispute resolution in the modern court system. The major ADR tool which was in use in the Caribbean before the turn of the century was arbitration, which assisted in the resolution of many disputes over the years without the need for court action. In the last 25 years, mediation was added to the toolkit as another device for use in the resolution of disputes without adjudication by the court on the issue or issues in contention between parties in legal disputes. Recently, another major feature has been added to the ADR menu in the Caribbean, that is, judicial settlement conferences, which have already become quite popular in the short time since their introduction in the Eastern Caribbean. Madam Chair, we will learn more about these and other forms of alternative dispute resolution from a prominent member of the Judiciary of Trinidad and Tobago, who has become a recognized expert on the subject, not just in Trinidad and Tobago, but so too in the Caribbean region and beyond. I invite you to listen to and learn this evening from the Honourable Justice of Appeal, Vasheist Kokaram, on a topic that you must be interested in if you are interested in justice and the law and the various modalities through which they can be advanced and enhanced. I thank you.
Thank you, Chief Justice. When we began to brainstorm on a topic for the second part of the lecture series, we wanted to choose a topic that was relevant yet informative, important yet captivating, and appropriate yet exhilarating. Of course, if we wanted to do one lecture with all those things, we had to get about 5 people wrapped up in one giant of a person, well, in the area, that is, who could deliver the total package, if you want to put it that way. But as much as I would like it to be, my job is not to introduce this person. It is my job, however, to introduce the person who's going to introduce the person. I couldn't probably call myself a lawyer if I didn't complicate things a little, right? Miss Jody Ann Stevenson earned her LLB from the University of the West Indies, Mona, and later obtained an LLM in International Commercial Law with distinction from the University College London as a Chevening Scholar. Ms. Stevenson is an associate at Baker & Partners in the BVI, specializing in dispute resolution with a strong focus on insolvency and restructuring. Beyond her practice, Ms. Stevenson is a fellow of the Chartered Institute of Arbitrators and chair of the Chartered Institute of Arbitrators Young Members Group, the Caribbean branch. She's an active member of a number of associations, including the BVI Bar Association and the BVI Arbitration Group. After Ms. Stevenson's introduction, the next voice you will hear is that of our keynote speaker. Please help me welcome Ms. Jody Ann Stevenson. Thank you.
Good evening, everyone. Thank you for joining us this evening at the ECSC's public lecture series. I recognize and adopt the protocol that has been established by your chair. I have been given the honor this evening of introducing our esteemed keynote speaker, Justice of Appeal Vasheist Kokaram, who will be addressing us on the topic, the Court, ADR and You. Justice Kokaram is a judge of the Court of Appeal of Trinidad and Tobago. He previously served as a judge of the High Court from 2009 to 2020. Prior to his appointment to the bench, he was a partner at the law firm M.G. Daly and Partners, specializing in industrial relations, public law, international trade, and mediation. He was also a community mediator, appointed under the Community Mediation Act from 1988 to 2005. He also served as a temporary High Court judge in 2006 on a backlog reduction project in which he commenced the use of judicial mediation. He is a member of the Singapore International Mediation Center Specialist Mediator Panel of the Caribbean since 2024. Justice Kokaram was a 2010 chair of the Court Annexed Mediation Pilot Project and currently serves as a member of the ADR Implementation Committee in the Supreme Court, Trinidad and Tobago. A judicial trainer certified by the UCL Judicial Institute, he has conducted JSC sensitization and training sessions for registrars and judges. He has also served as a judicial settlement officer since 2009 and conducts judicial settlement conferences in commercial, family, and appellate matters. Justice Kokaram was the chair of the Mediation Board of Trinidad and Tobago, the MBTT, between 2010 and 2018. As chairman, he advocated for the use and application of mediation as a means of developing a more peaceful and productive society. Between 2010 and 2018, he led several public education campaigns on mediation at the MBTT, which convened several national annual mediation symposia and produced publications on mediation and certification. Justice Kokaram has also played an active role in molding the minds of future legal practitioners as an associate tutor at the Hugh Wooding Law School since 2005. Currently, as a tutor in civil practice and procedure, he promotes the development of settlement plans as a key component in the attorney's pre-action and case management strategies and the development of collaborative law practices. In March 2022, he launched the Peace Jurisprudence Clinic, the Healing Hub, as a component of the Students' Legal Aid Clinic program at the Hugh Wooding Law School. He has also made presentations at numerous judicial and legal workshops and conferences, regionally and internationally. Ladies and gentlemen, distinguished guests, please join me in giving a warm welcome to our keynote speaker, Justice of Appeal Vasheist Kokaram. Thank you.
Imagine a world without lawyers. A world without judges. But instead, peacemakers and collaborators working with disputants and guiding them to make practical choices to resolve their conflict and help them achieve peace. Good evening, ladies and gentlemen. The Honourable Mario Michel, Chief Justice of the Eastern Caribbean Supreme Court, the Premier of the Virgin Islands and Minister of Finance, Honourable Natalia Wheatley. I wish to adopt your opening remarks. Let's have cocktails. Yeah. Judges of the Court of Appeal, the High Court, masters, ministers, attorneys, distinguished ladies and gentlemen who have been identified and saluted by our capable and able chairperson, Registrar Michelle Tibbles. I wish to adopt her salutations and welcome you all this evening as peacemakers this afternoon. It's a privilege to be here, and I congratulate the Honourable Chief Justice and his team for hosting this public lecture series designed to engage the public on critical aspects of our court's work in promoting the rule of law and access to justice. In engaging our main stakeholder, the public, we seek to demonstrate that justice is not the reserve of the few, held to ransom by some wise wizards in a tower whispering indecipherable languages to concoct a conception of justice which is disconnected with the lived experience of the litigants. That cannot be justice you seek, nor is it the justice which we seek to deliver. I would like in this presentation to demonstrate the great potential of integrating the processes and the philosophies of the ADR movement into our traditional legal system, which would lead to a reimagining of our judicial systems by making justice real, relevant, and humane. I begin my presentation with a Caribbean adaptation of a famous parable by the Prague novelist Franz Kafka. Some of you may have know this one, the Doorkeeper of Justice. This adaptation of a story of a villager, I will call her Mary. She's embroiled in a dispute, breach of contract. She is upset and she is seeking justice. Mary learns of the bold promise that the only way to resolve her dispute is to take a journey on the magic aircraft called Flight Justice. She drags her luggage hastily packed with all her anger and bitterness and anxiety generated by her dispute, and she's given a ticket to board this Flight Justice. To get to the entrance of her aircraft, she steps over a fallen banner which says, "All citizens seeking justice, get in line for your next flight to your trial." She is bristling with hope, anticipation that her journey will take her to the destination of resolution. But to her surprise, she is not alone. She finds several similar travelers dragging their own luggage, carrying their disputes, standing in line, waiting to board this Flight Air Justice. Some with suitcases carrying grouses with neighbors who encroached on their property. Others have luggage filled with complaints about the government. I didn't get the protocol list before I did this. Another got bit by the village dog. Mary is at the head of the line, and a tall, imposing flight attendant appears and stands between her and the doorway to her aircraft. But after hours, nothing is moving. She turns behind her and asks someone in the line, "What's going on?" And that person sucks his teeth and says, "Lady, may I know now? It looks like there's only one plane at here." Mary is worried that this delay may cost her. So she asks the attendant, "How much will this cost me?" The attendant says, "Excuse me, we don't know the cost of this flight. We will bill you at the end." Mary stands awkwardly, the wait now standing there for months. She asks the attendant again, but how long will this flight take? Flight attendant says, who knows? There's only one plane to take the whole lot of you. With rising feelings of anguish and despair, she waits years and years, and then she asks another question, would I ever reach my destination? And the attendant laughs, who knows where this plane will land? We can't guarantee that, ma'am. Just be glad you're getting out of here. Mary sits deflated on her suitcase of worries as years go by, and she asks, why did I bother to take this journey? And with her dying breath, she sees the flight attendant now nearing the aircraft door, and the aircraft attendant says, what, you still here? We are now going to close these doors. And Mary squeals, but didn't you promise me that you will take me away from my misery? And the attendant says triumphantly, oh yes, we did, but just not today, and closed the door in her dying face. This Caribbean Kafkaesque portrayal of the doorkeeper of justice makes the point relevant to this afternoon's discussion. How can a system of justice be sustainable if it can give no guarantee of its cost, no guarantee of its timeliness, no guarantee of outcome? That one flight that Mary encountered reminds us that we must guard against the inefficiencies, inaccessibilities, and incomprehensibility that can mar our systems of justice. And like the flight attendant, as doorkeepers, we have to remind ourselves as attorneys and as judges that in our actions, in our attitudes, in our outlook, we must not ourselves become barriers to justice. Mary's feelings of exasperation, disappointment, dehumanization is a lived experience of most litigants and an unfortunate byproduct of the adversarial system of justice. Written over a century ago, Reginald Smith commented, nothing rankles more in the human heart than the feelings of injustice. It produces a sense of helplessness, bitterness. It leads directly to contempt for law, disloyalty to government, and plants the seeds of anarchy. A conviction grows that law is not justice. And as the long lines can attest that Mary had encountered, our legal system is inundated with a heavy caseload, both in civil and criminal. But Mary stood in that line because that was the only option she thought she had. And it's symptomatic of three things. One, that we are wired on a reflex, impulsive reaction to conflict by trial, by combat. Two, we are unable to properly manage conflict, and we are not properly tooled or educated to preempt conflict. And three, we are unable to access different bespoke options to effectively, efficiently, and humanely treat with our unique human problems. So this afternoon, I want to lead a discussion on how we as judges and attorneys, the gatekeepers to justice, can lead a transformation of the life of the litigant by viewing ADR as integral to societal development, with benefits that can be transferred into our societal agenda to build more resilient societies, more robust in managing conflict, and creating positive peace outcomes. The role of ADR is much more than alternative. It is adaptive and reimagines justice to make it humane, real, and relevant. So I want to deal with this in 4 parts. And each of these parts, I will tell 4 stories. First, is our present adversarial reflex to resolve conflict sustainable? Second, what are our instincts for peace in the ADR movement? Third, how can the courts harness the benefits of the ADR movement? And finally, the blueprint of what the future can look like by integrating the ADR movement. I will spend most of my time on the first 3 components to lay the foundation for the blueprint, which can be taken up in more detail in another lecture. First, is our present adversarial reflex to resolve conflict sustainable? So my first story is one of my cases, fresh out of law school. A client was very upset that his neighbor had erected a fence and a gate over his property line. That impeded his access to his home by a dirt track which he used over 30 years. A clear trespass. My client had a prescriptive right. It was a violation of the law. I rushed to court to get injunctive relief. I had precedent on my side, cases on my side to establish the right of my client. There was an obvious injustice to caused by his neighbor. I destroyed the legal arguments of his opponent. I demonized his neighbor, and I called that fence the Berlin Wall that should come down. And then in my mind, I began thinking about preparing this client for trial after I'm finished with this injunction. Get his witnesses, bring the whole village, take this down, carry and kill this neighbor. Well, not kill, but in my mind. And of course, it might take months, it might take years, but I'll send them my fat invoice. But the judge, after hearing our arguments, looked at the client and asked, "Sir, what is it that you really want?" My client stood up and said, "Judge, I have no beef with my neighbor, we used to get along. All I want is a spare key for the gate." Well, so, entire matter settled that afternoon. My client complimented me on a good job. He left a happy man. I went back to my office to report to my partners, and I felt, did I just lose a case? But wasn't I trained to win? So there are lessons here. One, the search for practical solutions and problem solving comes with an important question that judges and lawyers seldom ask, and it's so important. Why? Why is this important to you? Two, it shows up the competitive system of justice, which simply pits parties as opponents for the sake of opposition. Three, it shows the judge has a huge moral force in navigating disputes to a resolution. And four, if our energies were focused on searching for a peaceful outcome at a much earlier stage, preferably when attorneys are first engaged, it will result in more enduring agreements at a more efficient manner. So you see, lawyers and judges, we are all wired to see one truth. And the approach to conflict becomes a battle of the stronger version of right. And critical in the success of that approach is to destroy, criticize, and subordinate the alternative right. The danger of perpetuating that system typifies the perception of narratives in conflict, which envelops the entire societal response to any conflicting view of our coexistence. And so our societal inability to perceive, empathize, collaborate is one of the main reasons for the increasing levels of hostility and conflict at all levels of society. Another difficulty of this might of right in this system is its premise on the conception and focus on negative peace and not positive peace. The peace theories of Norwegian political science Johan Galtung looked at negative peace as simply the end of violence. And the litigation system promises just that. The dispute will end with a judgment. But positive peace is far more constructive. It sets in place the importance of peace indicators essential to the stability and development and sustainability of our societies. It provides for the conditions for adapting to changing conditions, a well-run society, and the non-violent resolution of disagreements, providing structures that preempt conflict and help societies channel disagreements productively. What if our systems of justice were recalibrated to focus on positive peace outcomes? Now, there are some important macro policy factors at play here. And it helps us compare the adversarial system with with the positive peace approach. First, the International Consortium for Court Excellence developed a useful framework of values which can inform our ambitions to improve the quality of justice. The framework sets out 7 areas of court excellence. I'll emphasize 3: integrity, accessibility, timeliness. These values intersect with 7 areas of court excellence. I'll emphasize 4: court leadership, court engagement, affordable and accessible court services, and public trust and confidence. We also have to bear in mind the United Nations Sustainable Development Goals, SDG 16, which calls on nations to promote peaceful and inclusive societies for sustainable development and access to justice for all. The World Forum Action Agenda 2019 advocated for people-centered justice systems. ADR's ability to enhance the court's processes to target and realize these values of court excellence and sustainable goals is evident. It makes court processes less complex, more accessible, and people-centric justice emphasizes the inclusivity and the ability for the litigant to be given voice, key markers for a sustainable method of resolving conflict, understanding joint futures, and building trust in the rule of law. So ADR provides a more participatory, personalized justice system that is collaborative and focused on positive peace. So, second story. What are our instincts for peace? So I'll share a story of a judicial settlement conference. It's a dispute between 2 companies, both engaged in the development and promotion of a unique software used in post-production systems, which is the first kind in the Caribbean entertainment industry. The companies had loggerheads over the terms of their partnership agreement. One company brought a claim for fraud, corporate oppression, breach of trust, unjust enrichment. There are several injunctions granted against another company, and millions of dollars are at stake. There are about 4 related high court actions. They went to mediation, but no agreement was arrived at. At the judicial settlement conference before the settling conferencing judge, the managing directors of both companies were present. The gentlemen expressed their views on the dispute, and it appeared that they enjoyed a very close relationship, which was at the core of the establishment of the business in the first place. They reflected on their respective values they've brought to the entertainment world, and they realized that the misunderstanding was a simple one, which had embroiled and built over the years and affected their personal family lives. They used to go out to line. They couldn't do that again. And their businesses were suffering. The matter was settled after 2 hours, but only through a genuine desire of these parties to share their perspectives and a genuine collaborative approach of the lawyers who helped the parties think about their future, their families, and their future business plans. Both gentlemen were in tears, hugging each other. Well, not really hugging. It was virtual. They were doing the high fives and so on, but they were in tears. And it's an example of the ADR mechanism, which is now well established in the Eastern Caribbean of the JSC, a private conference chaired by a judge who is typically not the trial judge, assisting the parties to negotiate a settlement to their commercial dispute. It's known as heralding a new participant-centered normative order. It bears some resemblance to a private mediation. I call it mediation on steroids, because the judge who's there, he wields explicit power and influence. He has high stock of individual and institutional reputation, and he can give, or she can give, a non-binding evaluative opinion to help in the process. Critically, in that process, the client gets his or her day in court, and they meet a judge who can, with compassion and empathy, deal with the underlying issues of this legal dispute. Many of us know here what is ADR, but a few footnotes are necessary. We know that in the Eastern Caribbean, there are two main pillars: Judicial Settlement Conference and a long-standing established tradition of mediation. But the ADR movement started a long time ago with the Pound Conference in 1975, which is the marker for its popularity, and the several types of ADR mechanism, starting from the more simple party-to-party negotiations, all parties conferences, where parties and attorneys meet together in their private, without prejudice discussions, mediation, where you have private discussions being chaired by a certified and a qualified private certified mediator to assist in the parties themselves arriving at a solution to their conflict. Conciliation, another type of mediative intervention where the conciliator actually volunteers opinions. The Judicial Settlement Conferencing judge providing these evaluative opinions. Arbitration, mini trials, which is a summary method of providing a non-binding opinion after a very summary form of trial, and then, of course, trial being the last resort. These systems are now treated as integral to the legal system and known as appropriate or adaptive, not alternative, dispute resolution systems. They are all collaborative, relatively informal, simpler, less complex, and preserves a degree of autonomy for the disputant. And in doing so, and preserving that degree of autonomy, creates a sense of self-worth, respect, and dignity in the process of achieving peace. Turning to mediation for just a moment, it's always said that mediation provides a more cost-effective method to obtain justice. And it's important for us in the Caribbean if we can do some studies on that to bring home that point. In a recent report conducted by the European Union, a survey of their member states engaged in mediation, they demonstrated in the data that the higher the success rate in mediation, the shorter the duration of the dispute resolution proceedings and the great amount of saving in time and money. So, for example, Belgium, using a baseline of 100 cases with an average mediation settlement rate of 75%, settling in 45 days, there's a weighted average of 172 days to resolve a dispute from the beginning of the filing of the claim, and 11,000 euros compared to 550 days in just simply an adjudicative process, and a cost of 18,000 euros. Even with a success rate of 50% at mediation, there's a saving of 81 days and 2,000 euros. And they have worked out that the break-even point for mediation is a 9% success rate or settlement rate. We in the Caribbean are well ahead of 50% of our settlement rates. I don't like using success rates, in my view. Settlement rates, every mediation is a success, getting parties talk. In 2024, the Eastern Caribbean Supreme Court made significant strides in utilizing JSCs. And there has been, in just a short period of time, 81 JSCs across various jurisdictions, with a 64% settlement rate. And that translates in terms of savings on human resources, and 3 additional trial matters per judge could be disposed of through JSCs without going through a full trial process. In appellate mediation, it's an experiment in the Court of Appeal in Trinidad and Tobago. I am pleased that the results have shown that even in the appeal courts, parties are willing to mediate. I know that in the Caribbean Court of Justice, they have also experimented with judicial mediation at the Apex Court. There is, in the appellate court system, in that pilot project, a 50% settlement rate at the appellate court. It explodes the myth that mediation cannot succeed where there's already a declared winner. But it's not always about the money or about backlog reduction. There are significant therapeutic benefits to be achieved by having parties meet face-to-face with a mediator or judicial mediator, where emotions are focused, motives, relationships, explanation of events, moral accountability take center stage. And finally, on this point, we return to the instincts of us as a people, a Caribbean people. What is our greatest asset? We are hospitable. We are known as warm and friendly. And the intrinsic appeal of ADR resonates to a sense of who we are as a hospitable and caring people. As we say in Trinidad, all are we is one family, that song, right? And it resonates with the DNA of our African elders, our East Indian elders, of the Panchayat system, of the elder systems, of the Ubuntu. And those communal systems demonstrate an important feature of achieving peace in community, peace in circles, where parties see the value of coexistence and that parties are prepared to forgo the past and move forward in the future. So we of all people here in the Caribbean are caring people and deserve systems of justice that care. I should also mention some strands of mediation in criminal mediation, but before I do so, I want to highlight that these influences in the ADR world comes together under the umbrella of what I have termed peace jurisprudence. So if we view positive peace as the product of justice, the ability to build attitudes to constructively deal with disputes, the peace jurisprudential approach is an accumulation of several influences in the ADR world: therapeutic jurisprudence, restorative jurisprudence, restorative justice, transformative mediation, judicial mediation, collaborative lawyering, holistic justice principles, creative problem solving, and a key facet of building on our culture and indigenous systems of justice. And a key connecting thread in all of this are the 3 C's of compassion, collaboration, and consensus building. And so peace jurisprudence represents to me a combination of mediation, restorative, therapeutic jurisprudence practices which places law and the concept of positive peace as an outcome beyond simply the legal resolution of a dispute. It recognizes that lawyers and judges have an important role of leadership in creating the environment for positive, peaceful change in the lives of disputants. And the law has to be carefully analyzed for its impact on the social realities of disputants. And legal processes will have to be designed to engage individual needs with outcomes collaboratively determined through humane systems. Therapeutic jurisprudence, for example, deals with notions of catharsis and empathy and sees law and legal processes as having the potential to promote healing. Restorative justice principles is a philosophical framework that views crime as injury and justice as a process for healing to take place. And so returning then to criminal mediation, these strands are re-emerging in the ascendancy of criminal mediation, and significant strides are being made in conferences, victim-offender mediations. And in my view, mediation is not only suitable for low-level crime, but even capital offenses, in creating circles and dialogue and venting. In the children's court in Trinidad, there's a system of peer resolution, which allows the juvenile who is found guilty of a crime to be judged by her peers who would listen to the voices of the offender, the victim, persons impacted by the crime and the community, and recommend steps for the juvenile to take to reform and rehabilitate. For me, that's a communal system in action. The Needham Point Declaration, made recently, demonstrated that the court should make greater use of ADR in the criminal justice system. And no doubt, the Needham Point Declaration was influenced by the view that crime is to be viewed as a public health emergency. And if we view crime in that way, we need to speak to crime through the language of restorative and therapeutic jurisprudence and peace jurisprudence. We cannot try our way out of that pandemic of crime. And the development of modern problem-solving courts and problem-solving techniques are better suited to deal with societal and mental health issues that manifest themselves as crime, such as drug abuse, human trafficking, and juvenile offenders, just to name a few. So the third segment, how can courts now champion ADR? All right, so let's summarize where we are. We know that simple misunderstandings can be the genesis of long conflict. The desire for peace trumps our desire for negative conflict. The maintenance and regulation of relationships is key to the pathway of peaceful solutions. Positive peace can be realized when parties focus on sustainable outcomes, and the right atmosphere must be created to harness our instincts for peace. How can the court create that atmosphere? So here's the story of Roger Carrington, a professor in the University of Trinidad and Tobago, carrying his luggage of disputes. In that luggage, he complained that he was wrongfully dismissed as a lecturer when UTT failed to renew his fixed-term contract. He raised the issue that UTT was in breach of the implied duty of good faith. The UTT insisted that his employment was terminable on 3 months' notice. In the management of that claim, the court offered the parties, why don't you try mediation? Roger Carrington said, yes, I would like to meet with my supervisor. Obviously, there's unresolved issues. And the UTT's lawyer says, no, this is a matter of principle. We have a constitutional right to a trial. All right, fair enough. Off we go to trial. UTT won. And under our rules, the loser pays the cost. Roger Carrington will have to pay the cost. But the judge took note that the failure of UTT to try mediation was unreasonable and penalized UTT with 30% of their costs. I wish it was all, but I shouldn't say that. But it demonstrates and sends a signal: do not unreasonably refuse to try an ADR. I have heard many reasons why parties don't want to go to mediation. I feel I have a strong case. I have a constitutional right to a trial. I got a letter last week from lawyers saying that they will not go to mediation as it would only result in the other side getting what they want. These are not good reasons not to try an ADR, and courts must now take a robust approach to penalize that conduct and to encourage robustly, if not mandating, parties to try a suitable ADR. We're not forcing you to settle, but we are helping you to resolve your true complaint. As judges, we must now accept that the CPR was never premised on a system of dispute resolution by trial alone. It was premised, as Lord Wolfe envisaged it, as understanding the need to use ADR to create a multi-door courthouse. Several doors leading to several options, and our court's role is to help you choose the right door and usher you through. Part 25 of the CPR puts that burden on the court to deal with the case justly, to actively encourage and assist parties to settle, making adverse court orders, making wasted court orders against lawyers, striking out proceedings, referring attorneys to disciplinary committees. These are all sanctions we could use to compel or to encourage parties to try ADR and to entice attorneys to integrate mediation into their case plans. There have been, or there is, considerable guidance in the UK on what should constitute unreasonable refusals to try an ADR, and that they have been provided by Halsey and Milton Keynes. Lord Dyson famously, if not controversially, listed some factors which he views as justifying why you may not try an ADR. There are two matters that I take issue with. The merits of the case. Lord Dyson thought that if you felt that you had a good case, or whether ADR did not have reasonable prospects of success, those are good reasons to back out of an ADR. But those merit-based approaches, in my view, should not feature so prominently in a judicial checklist as the reason not to try mediation. Any attempt to consider reasons to refuse mediation on a merit-based approach is counterproductive to considering mediation as a means to resolve the dispute. The reality is, nobody thinks they have a weak case. Everybody thinks they're justified in adopting their positions. And it misses the point of what mediation is about. It's not about the merits. It's not about arguing a legal case. The point is, through the skill of the mediator and judicial mediator, unearth motives, concerns, interests which drive your dispute and which are not reflected in your legal case. And so a party's own view of the strength of the case cannot routinely be a good reason to refuse. Disputes can end with apologies, could end with withdrawal of cases. People will be satisfied that they were heard. That's all that they want in some cases. Churchill and Merthyr, Tydal County Council, a recent case of 2023, the Court of Appeal, Sir Geoffrey Voss, Master of the Rules, has added a whole new dimension to this discussion. And building on the Civil Justice Report of the UK in 2022, which pointed out that mandatory mediation is not unconstitutional, in Churchill, which was a funny case, where Churchill brought an action against the county council because some housing authority, there was some nut grass that came across into his garden, and he's suing the county council. I would have just taken a weed whacker and just knock it out, but okay. But here's Churchill, Court of Appeal. And in Churchill, the council applied to stay those proceedings because there was a settlement procedure provided by the council. And the Master of the Rolls says that the courts can lawfully order unwilling parties to engage in mediation on any non-court-based dispute resolution process and stay proceedings so long as it doesn't interfere or impair your right to proceed to a judicial hearing and is proportionate to achieving the legitimate aim of settling the disputes. UK has now reformed their civil proceeding rules to include the power to order parties to mediation. Now, we, of course, in the Caribbean knew that a long time ago. In Jamaica, there was an automatic referral to mediation after filing your defense. But Singapore has taken it to a whole different level. In recent reforms in 2021, you can see that the civil procedure is now heavily influenced by the ADR movement. Notably, the law firms in Singapore, most of their revenue is derived from mediation. At least one law firm, 67% of their revenue comes from ADR. The first thing they did was to introduce or reform the overriding objective to include 5 ideals. One ideal of justice is to help parties obtain fair and practical solutions suited to your needs. That's an ideal. Second, it included mandatory requirement for parties to make settlement offers before you file your claim. And they included that parties must not unreasonably refuse to accept those offers before filing the claim. And they've said that the court can order the parties to resolve the claim based on those offers and suggest solutions that they think fit. Singapore. The 2019 Singapore Convention, before I leave Singapore, deserves mention. The Singapore Convention on Mediation with 56 signatories, and some of them with our trading partners, China, Singapore, USA, the UK, is no better endorsement of mediation, having that international backing to enforce international mediations, cross-border mediation agreements in the jurisdiction of another country, regardless of where the parties mediated their dispute. It has been hailed as an international instrument to give validity and force to this means of justice. I believe only Jamaica and Grenada, Spice Isle, has ratified that convention. And it's critical for us in the Caribbean nations to follow, having regard to the complexity of international commercial disputes and the need for effective remedies. So we have come a long way from the one flight to justice that Mary faced. So let's come to our last part of this talk. How do we integrate ADR, the blueprint of positive peace solutions? For those of you who might be nodding off, this is the last part. And I did promise you, I'll just give you some pointers that may lay the framework for another discussion. But I will end with my last story. I mean, I can't end without a little bacchanal from Trinidad, right? So, in this case, here's a controversy. Every year for Carnival, they come into court. Every year. If it's not steel pan, it's this one. So this is a judicial review claim concerning the appointment of a representative on the national body in charge of Carnival, National Carnival Commission. And on that commission should be one representative of Carnival bands. You have representative of Calypso and so on, but Carnival band. And that person must be most representative of bands in Trinidad. That's a big contest. So the National Carnival Band Associations, they weren't picked by the minister in charge of the NCC. The minister had favored another Carnival Band Association, Trinidad and Tobago Carnival Band Association. It just so happens, backstory, the Trinidad and Tobago Carnival Band Association that was picked is a more traditional band with clothes on. And the National Carnival Band Association, modern beads. Now, in the management of that claim, the judge met with the parties to establish the direction for preparing this claim for judicial review. With the parties' consent, the judge met with the parties in caucus, in privacy, to discuss their needs and their concerns over this dispute. The parties were allowed to speak openly and freely on a confidential basis. The minister was invited and she sent a representative. The judge summarized their concerns and left it open to them to continue dialogue. And they would have continued the dialogue, but because there were other persons who needed to be at the discussion, time did not permit. And so they opted for the expeditious route of getting a decision. But as the litigation continued, the judge, in delivering the judgment, offered a private, non-binding guide to the parties on how to address these problems and to prevent it from reoccurring. During the judge's interaction with the parties, mediation skills of empathizing, listening, reframing, identifying cons and issues, and generating options were utilized. What you're seeing is the birth of a new type of case management, where we engender a system to put the client as priority and give them voice and a feeling of being included in the process. And so the first change is our approach to case management, transferring our mediation skills into the case management room, focusing our attention on problem-solving skills, which is a totally different dynamic to the legal approach. And so we're not focused on resolving disputes, we're resolving the underlying problems. It's not rights-based, it's interest-based, it's not backward-looking, it's forward-looking. It's not the judge as an arbiter, it's the judge acting as a coach. Totally different mind shift. I've heard parties come to a case management conference and say, Judge, I'm here for directions. And I say, are you lost? We're not here for directions for trial. We are here to work on your client's case. And so some tips: look at the case as not a number. Create empathy, build hope, be future-oriented, acknowledge history, co-opt help, and prevent the revolving door of litigation by searching for permanent solutions. Even in drafting a judgment, careful choice of words and making the decisions more appreciated by those who are affected. Letters to children by judges in family disputes will be welcome. Other techniques are pre-judgment resolution hearings. Parties are given an advanced draft of the judgment if they are unable to settle, and given an opportunity to discuss that draft, to work out their own solutions if they can. Post-judgment discussions after the trial is over. The discussions can be led by a trial judge to deal with the judgment and its implications on the lives of the disputants. Second, there can be influences in outcome, creative problem solving in even the judicial outcomes, where the court is mindful of the impact of the law on the larger social problems. It's been used, for example, in the award of exemplary damages, where a portion of exemplary damages is given to the claimant, and another portion is used to build, in this case, in Jason Raymond, to be invested in a prison reform fund, which was important to deal with the problem of prison violence in that case. And finally, judging in a therapeutic key. And that is something that Justice Jamarad mentioned in Calvin Ramcharan in the Caribbean Court of Justice decision against the DPP, of using therapeutic jurisprudence in sentencing. And it'll be interesting to use the therapeutic jurisprudence as the lens by which we can interpret fundamental constitutional rights and its impact of the savings law on our society. Third, changing mindsets, public education, and I congratulate all of the mediation committees in promoting mediation. One tip is that mediation education needs to be continuous and consistent. It's a new language we are teaching our publics, and the younger the audience, the better. Chambers of commerce and business should be incentivized to take a symbolic ADR pledge, ADR first before litigating. Some incentives to mediate can be tax incentives provided to those who try mediation, where a tax credit is given on mediation fees. You like where this is going? You should hit the next one. Judiciary rebates. Judiciary rebates your court fees after successful mediations. I've pulled these from places like Bulgaria, Romania, Italy. Incentivizing internal conflict management policies. Managing conflict within the judiciary. Judges and staff, staff and staff. Judges and the executive. We need to see about ourselves first and lead by example. Changing roles. For attorneys, we've seen the rise of a mediator, a mediation educator to educate your clients on the use of ADR, to advise them on proper negotiating strategies. Pre-action conduct must have an ADR component. You must be a mediation advocate, attend mediations, attend your judicial mediations, become problem solvers, and develop a practice of collaborative lawyering, the system that has gained currency in North America, where attorneys enter into retainer agreements with their clients and with agreements with the opposing attorneys and their clients that they will represent them in negotiations. And if the negotiations fail, the retainers of both attorneys come to an end, which shows that they are vested in negotiating your outcome, and they sign agreements with experts to assist. It's used often in family disputes, where you would now hire jointly financial advisors, counselors, coaches to assist the party. Legal education reform, incorporating compulsory mediation concepts and ADR training, perhaps minimize trial advocacy and focus on case management problem-solving skills, reforming the code of ethics for lawyers, attorneys. It's not shaped along the lines of what a collaborative lawyer is, and so the ethical duties to inform and participate, ethical duty to collaborate, the ethical duty to act in good faith needs to be spelled out in that code. Fifth, for the future of mediators and judicial mediators, a continuous development program, certification and specialization, such as in criminal mediations, intellectual property, sports, international commercial mediation. For judicial settlement conferencing, we are in dire need of increasing the pool of resources, and we can look at retired judges, we can look at senior counsel at the bar to become part of that pool and develop ethical standards for judicial settlement. Six, looking at future systems, we definitely will have, based on Churchill now, look back at mandatory mediation, mandatory pre-action mediation. I would like to see options given to client to accept binding arbitrations and binding judicial settlement conferences. AI will be important to support pre-action stages where the litigant will visit a portal and be prompted by several bots to offer solutions in the form of early neutral evaluations. And in terms of our problem-solving courts, we can do well to look at further juvenile justice systems, family courts, human trafficking courts, public law, and land and insolvency matters as well. And finally, an international peace center, after ratifying the Singapore Convention. And with an international peace center, the judiciary can legitimize ADR processes, making it available regionally and internationally, and build a culture of the ease of doing business here in the Caribbean. 50 minutes, I'm done. I hope with all of this that Mary will be pleased. Her estate. Thank you, Chief Justice. And for generations to come. Conflict is as much a normal feature of human existence as is an adversarial approach to conflict its abnormality. The more we infuse humanistic approaches to conflict in our legal world, the closer we realize social justice and strengthen positive peace outcomes and the legitimacy of our legal system. The more lawyers and judges play an active part in facilitating peaceful outcomes, the greater the respect is generated for the rule of law. And for Mary, well, and her estate, and her luggage of disputes, our promise to them is to integrate these adaptive forms of dispute resolution processes to provide a platform for generating positive peace outcomes, to lead to a transformative legal system in which justice is made more real, relevant, and humane. Thank you. Oh, I should end with this. There you go.
Distinguished guests. It's the clicker. It's the new clicker. Please put your hands together for Justice Kokaram. In one very fitting word, wow. You have given us, Justice Kokaram, another way, an alternative way to look at ADR. And we're so thankful for you sharing your knowledge of us today. Thank you so much. Ladies and gentlemen, I am so very happy that we decided to choose this topic, and even happier that we decided to go with Justice Kokaram. Let's give him another round of applause, please. We are now at the juncture of our program where we'll entertain any questions from the audience or persons online. Certainly. I think there's a microphone right there. On?
Mike?
Yes.
I am suspicious of every time I'm told that something is good for me. Whether it was the Avon product many years ago, or the bank telling me that this new loan will offset everything else, only to find out that I'm paying more interest at a longer rate. You have presented wonderful, I enjoyed, but why shouldn't I be suspicious of you? And if I was a lawyer, I think I would hide you. Because you've given us this wonderful alternative. Aren't lawyers going to be making less money? Aren't you affecting my bottom line? I just thought I'll ask.
Thank you. Thank you for the comment/question. No, but, you know, with the ADR movement, you know, they always say, you know, it's like some lawyers watch it as like bad medicine. You know, remember Buckley's? They say it tastes awful, but it works. But the thing is, it's only when you try it, you would see the benefits of it. That's one. And I have seen so many converts, some gladiatorial lawyers, forced into the mediation room. When they finish, they're singing praises. They want to, we should do this all the time. And that conversion only comes when you try it. The second thing is the cost factor is always an issue. But I always tell attorneys, bill for your hours. Nothing is stopping you from billing. Your reputation for getting your clients solutions, that's a high premium. They'll see you as a man who could solve problems, a woman who could solve problems. And that's why I pointed to the Singapore model, where the majority of the income is being made on ADR. I think it's just a matter of rewiring how we look at disputes and how we make money. Well, not make money, but actually make money, but we can still survive. We can still survive, yeah? So, but it'll be interesting to do the studies on it, to drive home the point for the bar that here is a model and what is the most cost-effective way of them doing business. Thank you for that.
Thank you for that question. Do we have any other questions? Any questions online? Oh, I'm sorry. Yes, we bring it. Just.
Thank you. Justice Kokaram, I am concerned that as persuasive as you are and will continue to be, the education of the public is not sufficiently engaged. Because we are, as a society, We are suspicious of each other. We are disputant by nature, so that it is a paradigm shift to get people to buy into what you're talking about. And my real question is, what are the institutions and organizations and persons who understand what you're talking about and understand the meaningful results at the end of the road? What more can we do to educate the public to make that paradigm shift?
That's an excellent question, Judge. And judges from Trinidad, where a psychologist said of us, there are high degrees of lack of trust in our society. I think as Professor Hutchinson said that of us. The only thing that Trini trusts is the next person is not to be trusted. But so it's a paradigm shift, as Judge is pointing out. And so there are two ways that I can think of right off the bat: formal structures and informal structures. The formal structure starts in our schools. I spoke about changing the mindset of the legal education program, because lawyers leads the language of dispute resolution. And we've done it for many years and centuries in an adversarial way. When we start to change that language, it filters down. Formal education in our schools, school curriculum. We've tried at the mediation board to get it on the curriculum. It's very challenging because the curriculum is packed. So a lot of work will still need to be done to do that there in higher institutions as well. And then finally, on an informal level, where leaders in society can adopt this approach. And we've always made the case that this is where the politicians come in. I noticed the Premier, so I can speak openly. But there is a place in our society, for example, as past premiers, past presidents, past prime ministers, in being trained in the tools of mediation to come back into the political landscape to help resolve high political problems. And when the society sees that, and sees perhaps the language of politicians, perhaps see the independent senators who are trained as mediators and using that language in the parliamentary chambers. Again, this might be a hard sell, but leading by example. And that's why, if you come into court and you see judges acting in a certain way, that filters back into the community to leading by example. So that immediately judge the formal and informal structures that I can think of. And the public like to see this. I don't know. No, this is very, very. I was so happy, Chief Justice, that you have this, your continuous drive. Well done.
We can take one more question, if there's anyone else who has a question. There's nothing online. Okay, so we'd like to thank you for your questions. Thank you, Justice Kokaram, for fielding these questions. At this time, I would invite His Lordship, the Honourable Mr. Mario Michel, Acting Chief Justice, to make a presentation to Justice Kokaram.
Something else. So I have to trust you. So on behalf of the ECSC Supreme Court and the Information Services Department, which has been collaborating with me in this exercise, I want to make a presentation to you Whatever very nice expression of our appreciation for you and the role that you play.
Please. It was G.B. Stern who said that silent gratitude isn't much use to anyone. And so it would be unpardonable of us not to take a few moments to express our gratitude to the many persons who worked so tirelessly on this event. To offer the vote of thanks, I would like to invite the Registrar of the Supreme Court of the Virgin Islands, Mrs. Vereen Vanterpool-Nibs, to give us the vote of thanks. Please make her welcome.
Good night, everyone. The task is mine this evening to give a few pointed remarks of thanks to all who contributed to this evening's success. I wish to begin with the Honourable Justice of Appeal, Vasheist Kokaram. Justice Kokaram, I knew going into this evening that it would have been a wonderful presentation. I said as much to you. And I dare say, my Lord, you nailed it. You nailed it. I thank you so much for your presentation. It was engaging, thought-provoking, and very educational. Thank you, sir. I really do appreciate it. Please give him another round of applause. I next turn my attention to His Lordship, the Honourable Mario Michel, Acting Chief Justice of the Eastern Caribbean Supreme Court. My Lord, I wish to express thanks to you for your vision in starting this public education lecture series. We are grateful that the territory of the Virgin Islands is the second stop in the series, but it's timely. The season is now for the education that has been launched. It's very necessary for persons to understand the court that serves them, and I am very grateful for this initiative, and I too add my blessing and trust that much seed and good seed would be planted, and from that there would be much growth and positive change. So thank you, my Lord, for your vision. Please give His Lordship a round of applause. Dr. the Honorable Natalia Wheatley for his welcome remarks. I wish to thank the Chief Registrar and Mr. Brissett for their dedication, their support, and certainly for pulling this evening together in the way they have. Thank you both. To our justices of appeal, or judges of the High Court, other distinguished guests, and to you for your presence here, persons before me, and those who are viewing and participating online, I say thank you for your presence. It's a testament that persons are in fact interested in the court, interested in the subject. If we were doubtful of persons' interest, I'm really pleased for the turnout. You made me proud. So thank you for being here. Great thanks. I would wrap up now, but I'd like to, of course, acknowledge the technicians and others who contribute and kind of contributed this evening. I cannot say thank you enough to the technicians. We are in a space in the world where we rely very much on our phones, and persons want to be here and there, and we can't do that without able technicians. So thank you. And with that, I would not prolong my couple of remarks. Thank you all for being here, and do have a pleasant evening.
Thank you, Madam Registrar. And so our time spent here this evening has come to an end. Bless you. And it brings me back to where I started. Relevant, yet informative, important, and captivating, appropriate, and exhilarating. These are just a few of the words to describe this evening's lecture series. It has been my esteemed pleasure to be your moderator for this evening. And as we bring this event to a close, the only thing left for me to do is say thank you to those of you who are here in person, those who are joining us virtually as well, across the length and breadth of the Caribbean and beyond. Thank you for your commitment to the court. And may we all look forward to many, many more milestones to come. Good evening. Thank you.